All right. Well, good afternoon, everyone. Thank you so much for coming today. I'm Amy Tenney. I'm the Assistant Dean of Academic Services and the Registrar here. We announced this event just over 12 hours ago. We have 2 full lecture rooms, and as of 12 o'clock, we have 117 people streaming and watching the event there. We're a law school that believes firmly in the rule of law, and that is what propelled us to sponsor this event today. I also want to make sure everyone knows we're a law school of immigrants, including our dean, our vice dean, and our dean emeritus. We also know that many of you are visa holders. We know that you're concerned on many different levels. So we want you to know that we stand with you, and we're going to help you through this every step of the way. As we go through the panel today, a few administrative notes. First, we're live tweeting the event. We're using the hashtag immigration ban, and we encourage you to live tweet as well. You can also follow the different handles that are on the screen. For the students who are in this room and in NT07, Dean Jaffe is going to be passing around index cards for questions that we'll try to incorporate into the discussion. After the initial presentations, which each presenter is going to present for 5 minutes, we may have time for some generic questions. After that, we're going to be closing down the live stream so that students in the room are able to ask their questions without any concerns about them being public. With all of those administrative notes taken care of you, I'm really thrilled to turn this over to our panel of experts, each of whom, as I mentioned, are going to be speaking for 5 minutes about the executive order and how it implicates their areas of substantive expertise. We will take questions afterwards. So we'll start with Professor Amanda Frost.
Good morning. I'm going to give a brief overview of the executive orders and some of the legal action that followed. I'd also like to mention quickly that there's a sign-up sheet going around for the Immigrant Rights Coalition. For those of you who are interested in being involved or just want to learn about jobs and internships in lots of different areas of immigration law, you might want to sign up for that. All right, so as I said, I'm going to give you background and overview on the Trump executive order. So on Wednesday, President Trump issued 2 executive orders. One involved the building of the wall, that is the expansion of a wall. We already have 880 miles of wall and fencing. And the other executive order changed the immigration enforcement priorities. It made the enforcement, it prioritized the removal of unauthorized immigrants who had committed crimes, which was also President Obama's priority, but also those who'd been even charged with crimes or had committed crimes but not been charged or convicted of them, but nonetheless had committed the acts. So he said he was going to prioritize the removal of those unauthorized immigrants. He also said he was going to ramp up detention and expand detention of unauthorized immigrants. He was going to reinvigorate a program that had been terminated by the Obama administration called Secure Communities, where the federal government works together with the state governments to try to detain and remove unauthorized immigrants who come to the attention of state government. And he was going to look into penalizing sanctuary cities, that is, cities that were trying not to cooperate with the federal government in immigration enforcement. And my colleagues on this panel will discuss that order in more detail. On Friday at 4:40, the president signed into effect a third executive order addressing immigration. This executive order did 2 primary things. First, it suspended all refugee admission into the United States. So even people who'd been approved and vetted and had their visas, had refugee status, would not be allowed to come into the United States. And he put that suspension at 120 days, except from Syria. From Syria, he made the suspension indefinite. And during that time, he wants his agencies to look into the question of the vetting and how to make the vetting of the refugees, extreme vetting is the term he used, and how he wants to make it, he thinks, more protective. And the second thing that order did is it said that anyone who is a citizen of 7 countries, Syria, Iraq, Iran, Yemen, Libya, Sudan, and Somalia, anyone from those countries is not permitted to come into the United States, regardless of their immigration status. So it applies to F1 students, it applies to tourists, it applies to H-1B temporary workers, and it applies to lawful permanent residents. That's what the order reads, that's how it reads. However, since Friday, there's been such an uproar about the barring of lawful permanent residents, people who may have lived here almost the entirety of their lives, and who were out of the country at the time the order was issued, that Reince Priebus went on a Sunday morning talk show and said, no longer is that the case. From now on, we will be letting in lawful permanent residents. And Kelly, the Secretary of DHS, has said that lawful permanent residents should be allowed in, although there's reference to reviewing them on a case-by-case basis. However, the other legal visa holders, those F1 students, tourists, temporary workers, would appear to remain barred from entry by this order. And as many of you know, if you've been following the news, many of those people were in the air or just taken off when the executive order was signed, and they've been held at airports like Dulles, JFK, et cetera, while either they wait to be determined whether they can come in, or some of them have been put on planes and required to leave. There's been a lot of litigation over the last 48 hours. Groups like ACLU, National Immigrant Law Center, law clinics have filed lawsuits. There have been 4 district court orders addressing this. The 2 I'll mention briefly. Judge Leonie Brinkema in Virginia issued, I think, the very first order. She said you can't deport a lawful permanent residents. The 2 named plaintiffs in that case were Iraqis who feared for their lives in their home country, and one of whom helped U.S. Military and was at risk for that reason. And she also said they need to have access to lawyers. They need to be given access to lawyers, everyone who's been held by CBP as they come in. And so far, I believe that has not happened, which is, I find, extraordinary. And then the second order worth mentioning is from Massachusetts, where the district court issued a nationwide injunction barring the implementation of these executive orders and preventing the orders from going into effect. I do not believe that that is being implemented fully, although I don't have complete information on that. I'll stop there and let my colleagues weigh in.
Thank you. Next is Professor Bob Goldman.
Well, I'm going to, good morning, deal with some of the international law issues that are raised by the order, because they've been really very much overlooked by the press. In dealing with these, it's important to differentiate between, I think, 2 classes of persons. One are persons who would qualify as refugees who are in their country of origin, such as Iraq, or in third countries, such as Syrians in Turkey or in other countries, who are directly affected by the order. The second class of persons are those who would qualify as refugees, who find themselves physically within U.S. territory or otherwise under the control and custody of U.S. agents. Regarding the first category, why the United States is not a party to the 1951 Refugee Convention, the United States has ratified the 1967 protocol to that instrument, which, as the Supreme Court of the United States has recognized, incorporates by reference Articles 2 to 34 of the 51 Convention. Article 3 of the 51 Convention states, quite pertinently, that state parties shall apply the Convention without discrimination as to race, religion, or country of origin, which is exactly what the Trump executive order does. It really is hard to imagine a measure that could be so exquisitely antithetical to the object and purpose of that instrument, and as such, it's a flagrant violation. Regarding those who are in the United States under the control of U.S. agents, they may invoke the principle of non-refoulement or non-return in order to bar transfer, return to another country where his or her life or other fundamental freedoms may be at risk. This principle, which is embodied in Article 33 of the Refugee Convention, is absolute, non-derogable, and part of customary international law. The U.S. is also a party to the United Nations Convention Against Torture and the International Covenant on Civil and Political Rights, which are also relevant to the principle of non-return. Article 3 of the CAT, in particular, prohibits expulsion, return, or extradition of a person to another state where there's substantial grounds for believing that he would be in danger of being subjected to torture. Article 13 of the ICCPR is stated somewhat differently, but it is important that the Human Rights Committee, in opining about the fundamental obligation of states to respect and to ensure rights, in its general comment number 31, made very clear that no state party to the CAT could expel, deport, render, or otherwise remove any person from their territory where there would be grounds to believe that the person would be, where their fundamental rights under the covenant would be in jeopardy. Let me just say at the end, and then I'll stop, that the 1967 protocol, the CAT, as well as the ICCPR, are duly ratified treaties by the United States, which means that the President ratified these treaties with the advice and consent of the Senate, which means that they are under Supremacy Clause, the supreme law of the land, and that they're the supreme law of the land, and as such, they are binding on the executive branch, including the President of the United States. Thanks.
Thank you. Next, we'll move to Professor Andy Popper.
Okay. Good afternoon. As you may know, I teach administrative law and torts, and I'm chair of the admissions committee. And my interest in this started thinking about how this particular order affected us as an institution, our students, our applicant flow, and our current students who are here. And it went from there very quickly to contemplating the set of legal issues and challenges that this created. And then from there, thinking about how you as a community and how we as a community could react to it. So with that backdrop, I have a series of just quick issues I want to raise and then let this move on to my colleagues. The first is this. I think the best role that we play as lawyers and you as lawyers to be in a moment of crisis, in a moment of chaos, is to be calm and clear, to not be necessarily the firebrand, but to be the people who can think through and provide advice to those who need it. You have a special capacity to do that. And I urge you to find in yourself that sense of tolerance and also that sense of objectivity. I believe that's lawyering at its highest form. When you can address people in crisis and say, this is what we know, this is what this order says, this is what's clearly right or wrong with it, here's what we have to learn, and here's what we're going to do. If you can be part of strategy, then you will be genuinely serving. So that's one thing. Second thing, on Bob's point of bicameralism and presentment, which I would add to this, this is a great opportunity for you to understand how law is actually made. This executive order attempts to do something which is not how law is made. This is how a system is turned on its head. This is a system of checks and balances where the judiciary is trying to balance someone who appears imbalanced at the moment. And to know and understand that that's the task will be helpful for you. Third, if you look at what's being generated, the complaints in New York and in Washington, what you'll see is a reference, among other things, to the Constitution and the Administrative Procedure Act. The section of the Administrative Procedure Act that's in play, that's referenced in the complaint, involves administrative actions that are arbitrary, capricious, or an abuse of discretion or not in accordance with law. Keep in mind those phrases. What does it mean to be not in accordance with law? If you have an executive order that discriminates on the basis of race, religion, and national origin, you have an unconstitutional trifecta. So what's the remedy? The president clearly has the authority to issue executive orders, but the president does not have the authority to proceed unconstitutionally. So if you look at the complaint, you'll see some are framed in terms of habeas corpus or other remedies or request for equitable relief. These are opportunities for you to understand terms that might have seemed vague and uncertain when you took constitutional law or civil procedure, but are now right in your face. And just as a professor, want to urge you to take this opportunity. Understand, for example, what the U.S. Marshal Service actually does in implementing a court order. And as my colleague, Professor Frost said, what happens when there's non-compliance with a court order? After all, think about the Obama immigration program and the means that was used to stop it. Find some district court in some dusty Texas town to issue an injunction and have it affirmed through the Fifth Circuit, not touched by the Supreme Court. Turnaround is fair play. Turnaround is fair play. So we get to court. That means have faith. Maybe checks and balances isn't working through Congress, but it's certainly at the moment working through the courts, through the 16 attorneys general who have brought suit. You're not part of a system that's failed. You're part of a system that's working. This is part of a sleeping giant, the U.S. legal system that looks to me like it's woken up. And that gives me faith, and that gives me confidence. One last point. The ad hoc provision of a rule or an order without any basis is illegal. The ad hoc rescission of it is equally illegal. So keep in mind when something is done that's baseless, as is the case here, that we have an opportunity to act and act aggressively. Good luck to you.
Thank you very much. Next, Professor Mark Niles will also speak about regulatory aspects.
So I also teach administrative law recently to a few people I see here. And one of the things we talk about in the course is the way in which constitutional provisions, specifically the Due Process Clause of the Fifth Amendment in regard to federal actions, applies in administrative matters. So as Professor Frost mentioned, and as the new head of the Department of Homeland Security mentioned, talked about the case-by-case determination. So back to the first executive order, and even back farther to discussions by the Trump administration about how they were going to deal with immigrants, illegal immigrants, whatever sort of terminology they used. One question I think that's important to focus on is, to the extent that decisions are made to take actions that affect the resident status of people, the Due Process Clause applies to those determinations. The Due Process Clause of the Fifth Amendment applies to any resident in the United States. That means anybody who's here is protected by various aspects of the protections of the Constitution. And all the Due Process Clause, hopefully you folks remember, says you can't take away life, liberty, or property without due process of law. So obviously there are liberty interests involved here and life interests potentially involved here, depending on who it is you're talking about and what's going to happen to them if they're sent out of the country. And all the due process part means is you have to give fair procedures. And a lot of civil procedure, a lot of administrative law, a lot of constitutional law talks about what that means. But basically what it means is you have to provide procedures that are sufficiently reliable to reach a correct result in a case, and also, given the importance of the issues that are involved, provide the kind of protections that are necessary to be comfortable that the decision is correct. Oftentimes that involves the amount of notice you have, the amount of time you have to prepare. But one of the big issues, and it's a huge issue now, and I know our former colleague Jamie Raskin is dealing with this directly involved in terms of his constituents, is access to an attorney. And as Professor Frost says, as far as I can tell, looking at the journalism up until walking down here, folks who have been detained still haven't been able to see their attorneys. And that's both legal permanent residents and other people who are involved in this. I don't know, it's interesting. The Fifth Amendment does apply to residents who aren't legal permanent residents, but the Sixth Amendment in the most recent Supreme Court decision does not. So the lack of access to an attorney might be very different in terms of the way the courts deal with it between folks who are not legal permanent residents and folks who are. And I think one main thing I wanted to say, and has already, I think, been addressed, but is important to note, again, as lawyers, is the categories of legal permanent residents as compared to others who are involved in all this right now are going to be treated very differently by the courts because the nature of the constitutional protections are very different. But that's not to say that residents who aren't legal permanent residents don't still have constitutional rights. They do. Anyone who's within this country, within its borders, is protected by the Constitution to a certain extent, maybe not to the exact same extent as others. And that's an important thing to remember in all this that's easy to forget for folks who aren't lawyers and focused on these things. The only other thing I wanted to say related to is take a look at or think about the consultation that's been involved in this process. Some interesting articles have been written about the lack of consultation from the White House in terms of, I would say, 3 categories of important people involved in the government. Career officials in the relevant agencies, so the folks who are not going to be replaced with each different administration and have institutional knowledge in relationship to these things. New political officials, so the new appointees that the president has put in office, and then congressional officials who were involved in important committees. Basically, as far as the reporting has come up until now, the White House consulted none of these different groups for different reasons. Some for fear of leaks going to the press, some acknowledging that these folks had already expressed a disagreement with these policies, including the president's new head of Homeland Security. And some, they've said, I've heard on television, well, we didn't want to warn the people who might want to hurt us that we would be changing this program, so they would send people over. So as a matter of sort of political science, but also administrative law, these structures for consultation are very important to make sure that all parts of the government receive the expertise and the experience of everyone who's involved in the governmental structure, so that correct decisions have been made. We have these consultation rules oftentimes to avoid mistaken decisions. Someone might have an idea of something they think is a good idea, but consultation with experienced people who have been through this process for a long time can often avoid mistakes going forward. So that's just another factor related to administrative law that I wanted to mention. Thanks.
Thank you. And next, Professor Ira Robbins will speak about habeas corpus.
Thank you. Professor Frost mentioned that 4 decisions have come down in the last couple of days. In fact, last night another one came down from the state of California, so we have 5 rulings. In the last 48 hours, more than 30 cases have been filed in federal court. So in the next few days, we should see additional decisions coming down. What are the common denominators in these cases? You've heard about immigration. Certainly immigration law is an important common denominator. Some of the rights being alleged in these cases are also common, such as violations of due process, equal protection, the Establishment Clause under the First Amendment. But these rights are meaningless without a remedy to bring these rights before the courts. We need an avenue to get access to the courts, and that gives rise to another very complicated common denominator, and that is the writ of habeas corpus. The writ of habeas corpus has been used in all of these more than 30 cases to bring the alleged violation of rights before the federal court. So what is habeas corpus? We go back 802 years to Magna Carta in 1215. Not in this country, obviously. What does Magna Carta say? It gives a right to challenge arbitrary detention by the king. That right was brought into the United States through the U.S. Constitution, Article 1, Section 9, Clause 2, with 26 words that are not very helpful. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. It doesn't define habeas corpus other than by negative implication. It doesn't say what it is. It just says you can't take it away unless you've got rebellion or invasion, which arguably, and I think clearly, we do not have at this point. So that habeas corpus exists to challenge executive detention. That's the history of habeas corpus. But in this country, we have had quite a few habeas corpus statutes. The Habeas Corpus Acts of 1867, 1948, 1966, 1996, that extended this right to challenge post-conviction review. So post-conviction review to challenge convictions and sentences, whether given to us by state or federal courts. That part of habeas corpus has been extremely controversial. What is not controversial is executive detention and the ability of habeas corpus to challenge executive detention. That's exactly what habeas corpus has been designed for. So all of these cases that we're seeing, the 30-plus cases, are raising executive detention pre-trial, not post-conviction challenges regarding violation of federal constitutional rights. I'll make just 2 other points. Again, I'll say habeas is complicated. The lawyers dealing with these cases need to know a lot about the Constitution, need to know a lot about immigration law, but they also need to know about the writ of habeas corpus. because however clear the rights violations are, this remedy of habeas corpus is the vehicle for bringing them before the federal courts. Okay. Two other points. One is that although it is rarely used, the writ of habeas corpus can be used as a class action. You don't just have to have class actions under Section 1983, for example. It is possible to have habeas corpus class actions. We haven't seen the class action yet in any of the 5 cases decided, but the issue has been raised in more than a couple of the remaining cases that have not yet been decided. Next point is these cases at some point are going to go up on appeal, and they're going to get to the United States Supreme Court. We don't know which ones will be the ones to race to the top, but they will get there, expedited or otherwise. Keep in mind, we also have 8 justices on the Supreme Court. What happens if a case gets up to the Supreme Court and there is a 4-4 decision? Well, clearly it is an affirmance of the lower court by an evenly divided Supreme Court. Just one more point on that. I wouldn't be too concerned about a 4-4 split, because in the terrorism habeas corpus cases in the last decade, more often than not, Justice Kennedy has voted with the liberals to grant habeas corpus relief. Thank you.
Thank you. Next, we'll turn it to Professor Sunita Patel, who's going to talk about the intersection of these issues with criminal justice.
All right, I'm going to focus on 2 provisions in the Interior Enforcement memo, the executive order. In many ways, both of these orders, in particular the Interior Enforcement order, really uses the architecture that the Obama administration and even the Bush administration put in place to ramp up the utilization of the criminal justice system for immigration purposes. Full stop. One of the ways we see this is in Section 10, which takes away the priority enforcement program and reinstitutes secure communities. And Professor Frost talked about this a little bit. Secure communities is an information sharing program that allows the FBI and the Department of Justice, the Department of Homeland Security, and CBP to all share information about anyone that is booked and arrested, even if they are ultimately not charged with a crime. And how this has been used is really interesting, because what happened, and we've discovered this, I was involved with litigation around uncovering the information around this program. It's actually used to completely change the way identification systems are used in the criminal justice system. And so now, instead of just fingerprints, there is the technology to store other kinds of information. And it was sold to the public as a program against immigrants and to find criminal aliens. It's actually been used against everyone who's been booked, okay? What happened as a result of advocacy and widespread organizing around the country is local governments and states decided that they didn't want this kind of broad scale introduction of the immigration enforcement at the point of arrest. And federal courts found that that detainers, which is what's used to keep people in custody until the immigration agency could come and pick someone up. Federal courts found that they were in violation of the 4th Amendment, Due Process Clause, and actually the Immigration Act. And so this led to carve-outs and sanctuary policies where local government said it's against our morals and values to hold everyone in custody for immigration purposes. And that's sort of what is underlying other provisions of this order. So part of the order says that they will take away resources, federal resources, for cities that are holding themselves out as sanctuary cities that are trying to curtail the ability of the federal government to enforce the immigration laws. So there's a lot of questions there about the definition that's being used and how this will actually play out? Is this all federal funding? Is it only specific kind of federal funding? Like, what is actually at issue? And I think we'll see cities resist this order or not resist it, in large part based on what kinds of funds are actually at issue here. The other section I thought I would touch on is section 11, which is the one that directs resources to be devoted to the prosecution of criminal immigration offenses. Now, what's interesting here is that it assumes that this is not already happening. But in fact, prosecutions for immigration violations, entry, and illegal re-entry, that means coming back into the United States after being removed, actually makes up 52% of all federal prosecutions in 2016. So there's an assumption here that it's not happening, but it already is, and that's under the Obama administration. And so I would just say that the events from this weekend and all of these changes have really sort of invigorated protests and actions across the country at airports. And I think those actions set the stage for the legal momentum and the legal challenges that were brought. Without people at the airports, without people showing up in support of the communities that were trying to enter, the lawyers would not have been able to get the information that they needed to file their challenges. So I would say that this is the moment to think about how to get involved and how to get engaged in whatever way you want to, if you feel comfortable. I went with another professor, Sherzan Minwala, to Dulles Airport yesterday because we felt like we needed to do something. We did mostly non-legal work while we were there, but it helped us feel better. And so I would say that all of this sort of feeds into each other, the legal and the non-legal work supports each other. You're in law school at a very important moment, and it's important to think about how you're going to use your legal skills and this opportunity when you're in school and not with the large responsibilities that come after graduation. Thank you.
Thank you very much. Next, we'll turn it to Professor Bill Yeomans, who's going to speak about the legislative and political process.
Okay, thank you, Amy. I want to talk first a little bit about how this is a classic example of bad government. And Professor Niles touched on this, and it does have legal ramifications. This executive order, insofar as we can tell, was adopted with minimal consultation with other people within the government. The New York Times is reporting that Secretary Kelly, who's the newly confirmed Secretary for Homeland Security, learned about the order while he was flying on an airplane. He was being briefed on the order and was told while the briefing was going on that the president was signing it. And this is the Department of Homeland Security, of course, is the principal agency involved in the implementation. Secretary Mattis, who's the Secretary of Defense, apparently was told about 2 hours beforehand as Trump was heading over to the Pentagon to sign the orders. So there was no consultation with the people who were going to be primarily in charge of implementing the orders. And there seems to have been no consultation in the development of the orders across the board. Normally, good policy is developed through an interagency process where the stakeholders are all involved. They pitch in, there are discussions, and then once there's a product, it is thoroughly reviewed. And that's when the lawyers really step in and make sure that all the I's are dotted and the T's are crossed. That did not happen here. And we're told that there was review by the Office of Legal Counsel. The Office of Legal Counsel reviews almost everything the executive branch does that's of any significance. That seems somewhat unlikely. What probably happened is that somebody who was coming into the Department of Justice and will probably be working in the Office of Legal Counsel looked at it. It clearly did not undergo the kind of thorough review that OLC usually conducts. And this is a real problem, and it's a problem across the government right now in this period between the inauguration and between the time when the full political teams have moved into agencies. So what you have now in the agencies are what are called Beachhead Teams. And they are the early political arrivals, the political appointees, many of whom don't know much about the agencies, certainly don't know the people there, don't know the career people, distrust the career people for the most part. and are really not in a position to undertake serious policymaking or serious legal work. And so this is a dangerous period. And it is essential at this point that career people in the agencies get involved, because they are often the principal bulwark against an executive who is run amok. So that's the process thing. Congress, what's happening in Congress? Many political commentators have been looking for that issue that might be the wedge issue that separates Trump from Republicans in Congress. And some people think this might be it. I think the early response from members of Congress is interesting. There have been a few Republicans who have expressed some reservations. There have been probably a half dozen senators who have made negative statements. For the most part, though, they're kind of wait-and-see statements. There have been several members of the House of Representatives, Republicans, who have come out and expressed serious misgivings. You add them all up, it's probably about 25 Republicans at this point. That's not probably going to be enough to make anything happen. Democrats have said, and Senator Schumer has said this, and now Dianne Feinstein has said this, that they will introduce legislation, probably today, to overturn the order. That legislation will not go anywhere without bipartisan support. And so the trick to make anything move in the Senate is to get members of the other party on board. And also, a piece of legislation like this will be subject to a filibuster. So it's unlikely that any substantive legislation will emerge from Congress. The other thing that Congress can do, though, is to deal with this issue through the confirmation process. As most of you know, we are still in the middle of confirming the president's nominees for cabinet positions. And there are a couple that are teed up that are very important. One is Jeff Sessions, the incoming Attorney General. The Senate Judiciary Committee is supposed to vote tomorrow on his nomination. There can be extended debate in committee. There can also then be extended debate on the floor, although he can be passed with a bare majority. One other nomination that is important is Rex Tillerson, and there is a cloture vote scheduled for this afternoon on Tillerson. He's up to be Secretary of State. That can become an occasion for some extensive debate on this issue, and my time is up. Thank you very much.
Thank you. Our final panelist for today is Professor Anita Sinha, who's going to talk about her perspectives on the issue and what you can do to get involved.
Thank you, Amy. So just quickly, in addition to the executive order summarized by Professor Frost, NGOs working closely with the United States Citizenship and Immigration Services learned over the weekend that USCIS is contemplating the extension of the ban on these nationals from 7 listed countries to freezing the affirmative applications of these same nationals. And so what that means would be that nationals from these 7 countries who have affirmative applications before USCIS, there can be naturalization applications, green card applications, even asylum applications would be frozen. We have not seen the official USCIS announcement on this, but credible sources say that the policy may come out today or tomorrow. I'm still hoping the cooler minds will prevail, as was the case on the reversal of the LPR ban, but we're preparing nonetheless. So that's just another thing that may come down the pike. So how could you get involved as students, as lawyers, and as concerned citizens? I'm not going to give an exhaustive list, of course, but instead just some leads. The CARE Coalition, the Capital Area Immigrant Rights Coalition, carecoalition.org, is one of the amazing local organizations that's coordinating the volunteers at airports, specifically at Dulles, as Professor Patel mentioned. Volunteers who want to go to Dulles should report to international arrivals near baggage claim 15, as they say. And I believe most international flights arrive after 5. So keep that in mind when you think about planning your trip, but definitely visit carecoalition.org to get coordinated. CARE Coalition was also asking for volunteers at Farmville Immigration Detention Facility, which is the detention facility where individuals who are detained pursuant to the executive order would be taken. I think that there is no more call for volunteers, maybe because they're not being detained, which is good news. But the sign-up sheet in terms of the Immigrant Rights Coalition that's going around, IRC is very closely connected with those detention detention visits. So if that does get sort of upped again, you can find out through IRC. IRAP, the International Refugee Assistance Project, is also coordinating volunteers, attorneys to help gather statements from non-citizens who are being held at secondary inspection. They're very involved generally. IRAP is a great program. I know many of you are involved. So you can contact the AU chapter of IRAP to find out more information. Interpreters, right? So if you speak Arabic, Somali, or Farsi in particular, Lawyers for Good Government is coordinating interpreters to go to airports in this area, but also around the country. So we can provide a link to that sign up after this teach-in if you qualify. For WCL students, a library is always a tremendous resource. Professor Billy Joe Kaufman has said that this is a particular concern for the library. They're very interested in supporting students and alums who want to get involved, who want to even spearhead. They're planning a workshop, and you can contact Billy Joe Kaufman for more information. Also, I'm volunteering myself for discrete research that we may be needing down the line, both for clinic clients and for other efforts. And so if you're interested in conducting discrete legal research on the issue, please email me, Sinha, SINHA, at wclamerican.edu. Lastly, all of you guys can help in your home cities and states, right? So this is a federal issue, obviously, but state and local action is not only relevant, it seems to be the place where most of the movement can be made. And so you can call, you can email, you can even fax, yes, they do actually still take faxes, to your local Congress members, mayors, and governors to ask how they are speaking out on this issue. You can also ask them to show up and speak out at airports. So Cory Booker came to Dulles this weekend, I believe, and after his arrival, the Border Patrol suddenly started releasing people from custody. So, representatives and those people make a difference. You can also ask your mayor, city council members, and governors to either pass a sanctuary policy, Professor Patel talked about the sanctuary policy movement, or defend a policy that is in place. So far, I think only Miami has capitulated and reversed its sanctuary policy. It seems like we are in sort of solid grounds that way, but it doesn't hurt to contact your local official and ask where they stand on that or to help defend. I'll end there. I'll say that where there is darkness, there's also a tremendous space for light. And the light is the action being mobilized around this issue. Thank you.
Thank you very much. Thank you to all of our panelists. So I'm really happy to tell you all that since we started the panel, we actually now have more than 400 people watching on the live stream. So welcome to everyone who didn't hear the beginning of our panel. We are going to open it up to a few questions, and I commend you on the questions that you've turned in already. We'll open it up to generic questions for about 10 or 15 minutes, at which point we'll close the live stream so that students can ask any questions about personal concerns that they have. So the first question for the panel: what mechanisms exist to ensure compliance with the court orders pertaining to this matter?
This is, I don't actually want to equate them in any way other than as a matter of procedure, but it does remind me of school desegregation, where you had the state officials not wanting to implement the Supreme Court's orders. For those who've studied that, you know that eventually what had to happen is the federal government had to get involved to support the Supreme Court's orders. So here we have a very odd, different situation in which the federal district court has ordered, for example, access to lawyers, and it appears that Customs and Border Patrol officials, also federal officials, are not obeying those orders. And so it raises the stakes, right? We've got a clash between potentially two different federal branches of government. The courts do not have the power of the purse or the sword. They have the power of their rhetoric and the fact that we live in a country of rule of law. So what I foresee is that if this conflict goes higher, you'll get higher courts involved, you'll get voices in government involved that are obviously not the executive branch. And I guess I'm optimistic that eventually Customs and Border Patrol officials will do what the courts tell them. But the court has nothing but its voice and a handful of marshals. I cannot force the federal government through the power of, it doesn't have a military, it doesn't have a police force that can enforce this order. It only has its statements and the fact that we live in a country where it's become understood to be the norm that we do what courts tell us to do.
Professor Yeomans talked about how this might be a wedge issue in terms of sort of Republicans in the Congress. Everything Professor Frost said is exactly right. I remember an old story from a law school class, but way before my time, a professor asking, well, how does the court enforce its order? And no one knew. It's like one of those things where no one knows the answer. And ultimately, it's because the president has the army can go enforce it. And in this case, I think if there are court orders that are specific, that are being ignored by the executive branch, I think the Republicans in Congress, most of them, significant number of them, are likely to stand up and note that, and that would create the political impetus to move the administration. I think everyone's fear is that won't happen. My sense is that is, as a practical matter, the next line of defense, if you want to call it that. Politically, it will become so untenable to continue to ignore court orders if they occur that even this relatively insulated administration will have to succumb.
Well, let me just add quickly that the judge can hold individuals in contempt of court, which gives the power to incarcerate those individuals. And again, it has to be implemented. It has to be that somebody can be taken into custody. But once Customs and Border Patrol officials feel that they're going to be named and may suffer personally, that might also change their conduct.
Yeah, and I'll just add, it's the U.S. Marshals who would take them into custody, and they are directly responsive to the courts. So there is that mechanism, but it's very limited.
Yeah, and it has to also be activated. And so I think we contemplate additional suits seeking injunctive relief, asking for the Marshal Service to act. On the use of the military, you might want to brush up a little bit on posse comitatus, that we don't easily ask the military to become involved. That's what the Marshal Service is for. I want to just add one other thing, and that's both in international law and in domestic law generally. The force of public opinion is intense. This is a political process. It's not just a matter of the definition of an issue or the interpretation of a statute. And so you play a huge role in helping marshal public opinion. And I would take that seriously in terms of both at the state and local level and federally. You're in Washington. You don't just have the opportunity to go to Dulles or National. You have the opportunity to go down to the Hill, the opportunity to talk to your representatives. And that public opinion matters to them. In the end, if members of Congress don't get reelected, then the game is over.
And I'll just say quickly that in order to show the courts that the CBP and others are not following these court orders, you need statements. And so attorneys in Virginia and in New York are asking that we will go to airports, they take statements, there's a list of questions to ask, and those statements become affidavits that can go to the court to show noncompliance. So you obviously need the facts, which is where people can come in.
Thank you. Next question. Can you elaborate on the direct impact this ban has in comparison to the 6-month ban the Obama administration had in 2011?
Well, okay, I'll start. So my understanding of the Obama so-called ban is it wasn't actually a ban. What happened was that they discovered that there really was a glitch in the way that they were vetting Iraqis who were coming into the country. And so what they did was to slow walk the process while they figured out how to fix the glitch. And so there were a reduced number of people processed during that period. I think the difference is that was in direct response to an identified problem. It was clearly not arbitrary or random, and it was very specific to the place where the problem occurred. I think this is of a completely different magnitude. I mean, the scope is enormous, and you don't have the underlying justification that you had in the Obama administration. It's an interesting fact that of the 7 countries identified, no national from one of those countries has ever engaged in fatal terrorism in the United States, as opposed to a number of other countries that were left off the list. So this list has a quality of arbitrariness to it, and to do this on this scale is very different from what the Obama administration did.
Thank you.
I can pick up on that in just one respect, not with an answer, but just with a reference. In today's Washington Post, there's an article by Glenn Kessler comparing the Obama order from 2011 with the order from last week, pointing out how they are not really similar. So all you have to do is Google Glenn Kessler, Washington Post with today's date, and you'll find the article.
Thank you. And also for Professor Robbins, on the 4-4 decision concern, what are the odds of a 4-3 decision due to Justice Ginsburg's vocal opposition to Trump during the election?
72 to 28.
In favor of
We can only speculate on what the odds are. We don't know which case is going to get to the Supreme Court first. We don't know if these cases, when they go to the Court of Appeals, will be expedited, whether they're going to start with a very rare en banc review rather than 3-judge panel. So it's hard to say. It may be that one or more justices will recuse. We can get a 4-4 affirmance. We might get a 4-3 decision, but different players on the Supreme Court might have been involved in different aspects of the case along the way. Maybe Justice Sotomayor, maybe Justice Kagan. So we can't predict, certainly in terms of specific odds.
And it is worth noting that the president has said that he will announce his nominee for the Supreme Court tomorrow night. So depending on how quickly things move, we could have a full court.
Live at 8 p.m. Prime time.
Is there a legitimate argument in favor of this order under Korematsu, especially considering the lesser extent of this order's provisions?
Today is the 98th anniversary of the birth of Fred Korematsu. I provide that just for color commentary.
Anyone else want to elaborate on Korematsu?
Fred Korematsu challenged the Japanese internment in World War II. Very controversial case. It took decades before the United States government issued an apology. The United States tends to have a history of acting quickly in a negative way and apologizing decades later for the error. And it may be that we're in that same sort of period now, but the Korematsu case is a major case in habeas corpus law, definitely well worth looking it up, Google or otherwise.
I know that many of you have class at 1, so this will be the last question before we end the live stream, so we can take a few live questions from the audience. Trump's administration was mentioning to investigating sources such as social media channels on personal mobile phones while entering in the U.S. Is this legally allowed?
What?
So people who were entering the country were having their social media accounts searched. Is that allowed?
Yeah, so, I think frankly, you could take a lot of classes on this stuff, and we can't answer these questions in 3 minutes, but I will say that there is an extraordinarily greater authority to search someone when they're entering the country than at any other time. And there's been lots of examples of people coming in and out of the United States, including U.S. citizens, who've had their laptops and other electronic devices searched by border guards. And the Supreme Court has established that there is greater authority to search in that circumstance. So I would not be surprised or think it's easy to legally challenge. On the other hand, the challenges being brought today, there's a lot of questions about the extent to which the First Amendment protects non-citizens coming to the United States, or the extent to which the government can discriminate based on national origin when barring lawful permanent residence. And I think there should be challenges brought about the extent to which they can search people's electronic devices or get information about their social media use. So I guess there's a lot of leeway and discretion the government has when people come into the country from outside the U.S., if they're not U.S. citizens in particular. But I think there should be some limits, and I'm guessing we're going to start seeing the courts looking at that question.
Yeah, among other things, when you studied the Fourth Amendment, you learned that there were standing exceptions to the Fourth Amendment. One of them is border searches and statutory searches, where the statute in place supplants notice that you would normally get by virtue of a warrant. And so a border search or inquiry is standard form. When the basis, however, for the search is patently discriminatory and it's predicated on race or religion, then that exception is diluted to the point where it's hard to imagine a court affirming it. Just the same, thinking about Ira's comment, is it's hard to imagine a Supreme Court opinion that prizes Korematsu and finds unconstitutional a summary detention or a summary removal without due process. For any of those justices, it's just hard to imagine that that's the state of our legal system.
I don't think anyone in the panel talked specifically, I might be wrong, about one aspect of this, which is the religious aspect, the establishment aspect that President Trump a couple days ago in an interview with a Christian television station talked about how Christians were going to be treated differently in regard to this than people of other religions. The administration is now talking about it in terms of religious minorities as opposed to Christians in order to avoid arguments. And one of the potential arguments is going to be that having a rule that limits access to the nation based on religion constitutes a violation of the Establishment Clause of the First Amendment. So another, as Professor Frost says, another of many issues that are going to be raised, and be interesting to see how courts, through a process from lower courts to the Supreme Court, address these issues. That was just one more that I don't think we had talked about yet.
That's helpful, thank you.
And one other thing I would just note is that one of the provisions of the executive order authorizes immigration officers, these are very low-level bureaucrats with no legal training, to determine that someone can be removable if they pose a risk to public safety or national security. I mean, this is a very broad provision in the executive order and something that we should be troubled by.
Well, with that, we're going to end the live stream. For everyone on the live stream, thank you very much for attending. We put this together in 18 hours. We hope to continue having these kind of events. So if you're not following us on Facebook or Twitter, please do so at AUWCL. Sorry.